Good morning, students. Welcome to today's Essential Explainer class. Today, let us look into a highly critical topic for your upcoming examinations. We are tackling question number 8, straight from your university question bank. What are unfair labor practices? Discuss their prohibition and remedies. Now make no mistake, this is a standard 16-mark essay question, and I require your absolute undivided attention. You must approach this topic with clinical precision. Okay, let's dive into this material and see exactly how you are going to score maximum marks on your answer script. Here is your mandatory structural agenda. 1. Introduction and meaning. 2. Types of unfair practices. 3. Statutory prohibition. 4. Legal remedies. 5. Landmark case laws. And 6. Importance and conclusion. Listen carefully, students. This on-screen agenda is exactly how you must structure your headings on the KSLU answer script to impress the evaluator.
Heading number 1, Introduction and Meaning. This sets the foundation for a perfect university answer.
Central to maintaining fairness in industrial relations under the Industrial Relations Code 2020, earlier under the Industrial Disputes Act 1947. When answering, you must explicitly provide this historical context. You have to mention this statutory transition from the 1947 Act to the 2020 Code right in your opening paragraph. You see, the invigilator and the evaluator are specifically looking to see if your legal knowledge is completely updated, so emphasize this transition as a crucial historical fact for their attention.
Unfair labor practices, practices that violate the principles of natural justice, fair play, and collective bargaining, listed in the schedule of the code, applicable to both employers and workers. Students, mark my words, you must by heart these exact provisions. There's absolutely no room for paraphrasing the bare act. When writing this definition on your paper, I want you to literally take your pen and underline the phrase natural justice. It shows the evaluator that you deeply understand the jurisprudential root of the concept.
Moving to heading number 2, types of unfair practices. Prepare to draw a dividing line right down your exam paper for this one.
A. By employers, which includes interfering with unions, discriminating, dismissing for union involvement, refusing to bargain, and employing badly or casual workers to deprive them of permanent status. Versus B. By workmen or trade unions, which includes illegal strikes, coercion, refusing to bargain, and forcing recognition of illegal unions. Now, why am I showing you this side by side? Because visually presenting this direct comparison on your answer script makes the evaluator's job extremely easy. On the left side, list the employer's faults. On the right side, the workman's faults. An easy, structured evaluation leads directly to a perfect score for you.
Heading 3, Statutory Prohibition. Let us move to the strict mandate of the law.
The code expressly prohibits unfair labor practices. No employer or workman shall engage in such practices. Violation attracts penalties and legal action. You have defined the wrong. Now you must state the law that strictly forbids it. If you are attempting a 10-mark long answer question on just this prohibition aspect, you must highlight the word expressly. This is not a mere suggestion or guideline, students. It is a strict statutory prohibition that leaves absolutely no room for ambiguity.
Heading 4, Legal Remedies. Because, students, what is a right without a proper remedy?
Complaint to authorities, meaning the conciliation officer or industrial tribunal. 2. Adjudication, where the tribunal declares the practice unfair and grants relief. 3. Relief to workmen. 4. Penal consequences, such as a fine or punishment for violation. Remember the fundamental maxim, ubi jus, ibi remedium, where there is a right, there is a remedy. Carefully dictate these sequential steps in your mind. Without this procedural flow mapped out clearly on your paper, your 16-mark essay is simply incomplete. Mapping this proves your practical, courtroom competence to the university evaluator.
Relief to workmen includes reinstatement, compensation, and back wages. Let us focus heavily on these specific reliefs. When you reach this point in your answer script, I instruct you to heavily underline the word reinstatement. Why? Because it is the single most powerful relief an industrial tribunal can grant. Emphasizing it will instantly catch the evaluator's eye and secure those extra marks.
Heading 5, Landmark case laws. Now listen carefully. This is the absolute most critical section for securing distinction marks.
Bharat Ironworks v. Bhagubhai Balubhai Patel recognized unfair labor practices in employer conduct, and Hindustan Lever Limited v. Ashok Vishnu Kate explained scope and seriousness of unfair labor practices. Students, sit up straight and pay attention. A law paper without case laws is merely an opinion. We must do a deep breakdown of these two cases. For Bharat Ironworks, the brief background involved serious allegations of victimization of workers by the factory management. The final ratio decidendi laid down by the Supreme Court was that while the initial burden of proving victimization lies on the trade union, the tribunal absolutely has the power to scrutinize the employer's conduct. The absolute relevance of this case is that it strictly defines the legal boundaries of employer misconduct. Next, Hindustan Lever Limited. The facts here revolved around workers being deliberately kept as temporary casuals to deprive them of permanent status, a classic Budley worker abuse scenario. The court's ratio decidendi established the preventive jurisdiction of the courts. This means courts can actually intervene before the unfair labor practice causes irreparable harm. Its relevance is massive because it showcases the true protective scope of this legislation. Exam tips for you. On your answer script, draw a neat box format around these two cases. Underline these exact case names to immediately capture the KSLU evaluator's attention for a 10-mark or 16-mark answer.
Finally, heading 6, Importance and Conclusion. Prepare your pens for the final paragraphs of your perfect 16-mark essay.
Ensures fair industrial relations, protects workers from exploitation, promotes collective bargaining, maintains industrial peace. Before writing your final concluding paragraph, I want you to crisply list these precise points, just like this. It perfectly demonstrates your comprehensive, holistic understanding of the entire legal framework to the evaluator.
Unfair labor practices disrupt industrial harmony and fairness. The Industrial Relations Code 2020 provides clear prohibition and effective remedies, ensuring a balanced relationship between employers and employees. Deliver this exact phrasing on your paper with heavy judicial weight, and your answer script exactly with this quote. Now, before we conclude today's class, let me leave you with a final provocative question to think about for your future practice. Does mere statutory prohibition on a piece of paper truly guarantee harmony on the factory floor, or is the ground reality of industrial relations far more complex than a textbook schedule? Think about it. Keep studying, remember to by heart the provisions, and good luck with your examinations.